Get ready. 3 seconds. 2 seconds. Start. This appeal is directed against the judgment and order passed by Session Judge Tezpur in Session Case Number 39/96, GR Case Number 1055 of 1995, convicting him under Section 302 IPC and sentencing him to imprisonment for life and to pay a fine of Rs 1000, in default further imprisonment for 6 months. This is a case of matricide where the accused appellant killed his own mother. The incident took place around 11 a.m. on 26/6/1995 in the house of accused appellant, and he was sitting with his mother, brother and sister. The deceased was suffering from certain illness, and after returning from the hospital, she was sleeping in the veranda, whereas the accused appellant was sleeping inside the room. Thereafter, the accused appellant picked up an axe and hacked his mother on the neck, causing instantaneous death. In the present case, there is no eyewitness to the occurrence, and the prosecution has relied on circumstantial evidence as well as the judicial confession recorded under Section 164 CRPC, PW 2 and 3, being the inmates of the house. They were present when the incident took place, even if they did not see the actual incident of assault. Soon after the assault was met, the accused was apprehended. In this case, we find that at the time of recording deposition, the witnesses were asked certain questions, and the trial court recorded answers mechanically as if they are contradiction as provided under Section 145 of the Evidence Act. The statement under Section 164 CRPC cannot be recorded unless it is required to be proved for the purpose of corroboration or contradiction. PW2 has categorically stated that he saw blood-stained axe in the hand of the accused appellant soon after the assault, and as such, there is no scope for recording contradiction, though admitted by the accused in his statement under Section 161 CRPC. The witness did not tell police that he did not see blood-stained axe in the hand of the accused appellant. We have perused the CD available on record and find the case diary available on record and find that the contradiction have been wrongly recorded, as there was no scope for these contradictions. The fact that the accused was apprehended with the help of co-villagers stands well established. The weapon of assault was also seized. As regards the other points, whether the confession is true or not, we find that there is sufficient corroboration to the statement as regards the place of occurrence, nature of assault, and weapon used, and the site of injury. The medical evidence fully corroborates the statement in the confessional statement as regards the injury and the weapon used. The witness stated about the place where the incident took place and the manner in which the accused was apprehended. In view of the above material corroboration, the trial court held it to be the true version of the incident. So far, the evidentiary value of confession is concerned, we may refer to the following observation of the apex court. In the case of Bhagwan Singh versus the State of Punjab, AIR 1952, SC 214, The apex court held that the burden is on the accused to prove the confessional statement to obtained by threat, duress, or promise. The above ratio of law was reiterated by apex court in the case of K.I. Pabuni versus Assist Collector, CES 1997, SCC 721. Learned judges of the High Court declined to act on the said confession mainly for two reasons. First is that the confession was retracted by the maker thereof, and second is that the recovery of articles were made prior to the confession. We may state at the outset itself that both the reasons are too insufficient for overruling the confession. It is not the law that once a confession was retracted, the court shall presume that the confession is tainted. As a matter of practical knowledge, we can say that non-retracted confession is a rarity in criminal cases. To retract from confession is the right of the confessor, and all the accused against confession are produced by the prosecution have invariably adopted that right.